Please be seated. We have 4 cases on the docket for hearing this afternoon. And at the end of the second case, we will break for coffee. We invite each and every one of you to join us in the Commons for coffee if you're still around. I know some will be around. But okay, the first case this afternoon is Penton versus Larry Campbell in his official capacity. Is the appellant ready to proceed?
Yes, Your Honor, I am.
Great.
Madam Clerk, I would like to reserve 3 minutes for my rebuttal. May it please the Court, my name is David Switalski, and along with Allie Calico, we represent Dorian Penton Sr. as the personal representative of the estate of his son, Dorian Wayne Penton Jr. And Dorian Sr. and his wife Dorothy are sitting here in the front row. They are the parents of Dorian Wayne Penton Jr. This appeal is from a final judgment of dismissal from the trial court. In deciding this case, you must accept the allegations that we pleaded in the complaint as true, but not defer to the trial court's conclusions regarding the legal sufficiency of those allegations. The issue we're dealing with today is whether Sheriff Campbell owed a duty of care to Dorian Wayne Penton Jr. to timely contact and dispatch emergency personnel to the scene of his car crash after Leonard Inge reported the crash to the sheriff's dispatcher, and the dispatcher promised Mr. Inge that he would get somebody en route.
Well, the first deputy got there 6 minutes after the call was received, didn't he?
Around that time frame, yes. The issue here, if you look at the facts, the fire station was only a couple hundred feet down the road. And the dispatcher...
The fire department arrived 8 minutes after the first call.
Correct. Couple hundred feet down the road. The point is the dispatcher dropped the ball. Well, after the dispatcher made the promise to get somebody en route, the dispatcher did not do that. And if you
6 minutes strike you as an unreasonable amount of time under normal circumstances?
Well, I think the point is, had the dispatcher called the fire department or dispatched the deputy when Leonard Inge called, the deputy or the fire department would have gotten there in time to save Dorian Wayne. When they arrived, when the police officer arrived, he went to the car. The flames were too hot for him to get Dorian out, and he could hear Dorian screaming in there. He knew he was alive. Those 3 minutes in this situation would have mattered, and we believe that's something that a jury should be allowed to hear and make its decision on as to whether there was a breach of the duty. But what this appeal boils down to is one sentence from Pollock versus State Department of Highway Safety. All right, in that sentence, it talks about an exception in the public duty doctrine. It says, Florida courts have also determined that a special duty is established when a police officer makes a direct representation to a plaintiff or one so closely involved with the plaintiff that their interests cannot be separated, that he or she will take a specified law enforcement action. The first key to that statement is that it assumes there's an identifiable individual who is in danger or is in need of help. And the caller is calling on behalf of that individual. We have that here. You have Leonard Inge. He sees the wreck. He sees the car flying into the woods.
Mr. Switalski, doesn't your argument result in the conclusion that every time somebody calls a 911 dispatcher, there's a special duty assumed?
Oh, not at all.
Well, aren't they going to say something like that in every case?
Not necessarily.
What are they going to say? We're not going to send anybody?
No. For one, and a lot of times you will get, let us connect you to the fire department. They make no promise. They take on no duty. But as far as that's concerned, that is kind of a red herring in this case. That doesn't get them out of their duty. to have the duty, you have to have the call by a person who's calling on behalf of an individual. They're not making the call on behalf of the general public. Here, Leonard Inge was doing it on
Well,
behalf
you're saying that every time someone calls 911 to report something they have observed, they're calling on behalf of.
No.
Because, I mean, it seems to me your argument, if your argument is correct, why wouldn't the Pollock case have come out the other way? Because in Pollock, the man saw the semi-truck actually stalled on the Palmetto Expressway in the lane of traffic with its lights off, tried to contact the highway patrol, and couldn't get anybody there, and actually went out behind the truck himself to warn people for 20 minutes or whatever, and then finally left. If your argument is correct, why wouldn't it be said that that man was the agent of the person who got injured?
Because all you can say about that man, Raul Pedrero, is that he was the agent of the public in general. There had not been a wreck. There was no victim that had been identified. It was strictly a mere possibility, this looks dangerous, a car may run into the truck. The difference with Leonard Inge is the accident had happened. There was a specific individual who was in danger. In fact, there was no danger to the general public in this instance. And he was saying, I'm standing here at the scene. There's a specific car wreck with a specific individual who needs help. That's how it's different. And if you look at all those cases...
But as Judge Webster says, that's going to be the case all the time, isn't it? If I saw an accident out here on the corner, by the way, we have one about once a week out here, and called 911, someone would say, well, he was calling on behalf of the people who were in those cars. Well, maybe I was. But wouldn't that always be the case? You'd always be calling,
Well, there has to be...
And the dispatcher's always going to say, in this case, what did they say? We'll get somebody en route, something like that.
Yes,
And
sir.
now you characterize that as a promise,
Yes.
as if this was a contract between the EMS people and Mr. Inge or something, but wouldn't they always say something like that? They're not going to say, I don't see a 911 operator saying, I'm busy now, I'm drinking coffee, calling back later.
Well,
they're always going to say something like that.
They're not always.
And lawyers, good lawyers like you, are always going to come in and say, look, that was a promise that they made.
They're not always. And in fact, one of the cases that involved a car chase, and the victim was actually calling while being chased, talking to dispatch, and they spoke to the dispatcher for about 6 minutes before they got killed. The dispatcher never once said, we will send somebody to help. All the dispatcher did was say, here's the address of the police department. Why don't you try driving here? So I would disagree. The dispatcher's not always going to say, here, I'm going to send somebody en route.
Didn't the Tallahassee Fire Department then, according to your argument, assume a duty here too?
No, because the Tallahassee...
Didn't they say, we'll have somebody on our way in just a minute?
Not that I know of, sir. Not to Leonard Inge.
Well, to one of the other people who called, they did. Is that not part of the record?
If other people that were there made calls, the reason Leonard Inge matters is he's the one to whom the dispatcher made the promise.
Well, let's assume, for purposes of argument, that another passerby
Correct.
called the Tallahassee Fire Department and said, hurry up and dispatch someone because the car is on fire. And the dispatcher responds, the Tallahassee Fire Department dispatcher says, we'll be on our way in just a minute. Is that assuming a duty?
Not
How is that
necessarily.
different from this?
It's different because under the case law, you look to see whether a special relationship was formed. And part of the special relationship involves some type of reliance, reasonable or justifiable reliance on the promise of the dispatcher. And if you look in Pierre v. Jean, it lists 3 elements to have a special relationship. One of them is reliance.
I'm just having a hard time understanding how these 2 calls and these 2 responses are the least bit different.
You mean with Pollock in this case?
No, I mean the call to 911 and the call to the fire department.
Well, one of the differences is that Leonard Inge justifiably relied on the promise. He could have run down the couple hundred feet to the fire department. He didn't. He could have gotten in his car and driven down there. He didn't. And he didn't because the dispatcher said, we're sending somebody en route. And that promise was made to him. Now, the other people who called, I don't know if they drove away. I don't know if they were just in their car the whole time and just saw it and gratuitously called in. But they didn't rely on the promise. Leonard Inge did. And that's the difference here as far as establishing that relationship. And if you go back to Pollock, Raul Pedrero, who called in, didn't rely on it. He waited around for 20 minutes, got tired, and left. There wasn't some other action that he could have done to prevent the accident that he forewent because of the promise. Here, Leonard Inge did, and that makes a difference. Pollock is a true modeling public duty doctrine. You have a caller making a call on behalf of the general public. Leonard Inge, in our case, is making a call on behalf of a specific individual, and then he relied on that promise that the dispatcher made.
You think it's good public policy to adopt the rule you're arguing for here?
Yes. One of the things I mentioned in the brief is if it is not as I propose, you are now basing law on pure luck. And as one of the examples I gave, if one of you gentlemen happen to have a heart attack right now, and I make the call, and the fire department doesn't show up, you're out of luck. That's not what our
I don't understand that. I don't understand that argument, given the argument that you're making here. I guess because you wouldn't do anything else if one of us had a heart attack? Is that what you're saying?
What I'm saying is, as the sheriff proposes, on Pollock, it is very bright line. Either you're somebody's relative or someone extremely close with a prior existing relationship, or you're not. And if you happen to fall in that category where you're a relative or have a prior existing relationship, then a duty somehow exists. If you look at what Leonard Inge did, and you look what the people did in the cases where they found a relationship, Hartley, or St. George versus City of Deerfield Beach, it's the same acts. It would be bad public policy, I think, to rely on Pollock or interpret Pollock to have this rule of law based on luck of who happens to be calling.
But isn't Hartley part of your problem here? They promised to do a specific thing to the widow of the fisherman.
Yes.
And here you're running up against the doctrine that a duty to everybody is a duty to nobody, right? And you didn't have that in Hartley. Don't you sort of tend to have that here? That you call 911 and it's just a general duty and it doesn't mature into a specific duty until they promise some specific act beyond, as Judge Padovano says they'll say in any case?
I would say, if you look at Hartley, it's the same as St. George versus City of Deerfield Beach. There, the paramedics told the ex-wife, things get worse, call us, we'll come back. That's not much different than saying, we're sending somebody en route. And in fact, in that case, the court said the duty was created when the wife made the second call to 911. So I see I've run out of time and would like to reserve the rest for rebuttal.
Good afternoon. Excuse me. I'm Barbara Fromm, representing Sheriff Campbell, police the court. This is a tragic event, and I'm not going to diminish anything here. This is just a very, very sad event. But my argument is simple. I think that the Pollock case by the Florida Supreme Court completely controls this case. I don't think there's much of a difference at all. In Pollock, the accident hadn't happened yet. In Pollock, they never did dispatch anybody. In this case, we've got a deputy who basically heard what was going on and said, can I help? And she said, yeah, go. He gets there in 6 minutes and does everything he can. Mr. Ng, I think, I'm sure, was a well-intentioned citizen. But if you look at the complaint, what did he do? He said, all he ever said, that a car had flown through the woods. He never mentions a child. He never mentions anybody injured. And they say,
are you saying to create a duty, they've got to know the name of the person or something like that?
No, they do not. Absolutely, Your Honor, they do not. But when you look at this language, and I agree that this language in Pollock it's unusual language to have to interpret, but it talks about The special duty is established when they make a direct representation to one or someone so closely involved with, they use the word plaintiff, I think you use the word victim, that their interests can't be separated. What I have a problem here is I don't see any real interest other than an accident that happened that may involve injuries, may involve people, may not involve people at all. That's basically what he reported. Now, you had other Good Samaritans who did the same thing, and you're absolutely right. The one, I think it was a woman, who said, the car was on fire, and it was a man. A woman first called and said that someone's trapped inside and the car is smoking. They transfer her to Tallahassee Fire Department, so they're aware of it. And then there's a third call, according to the complaint. Doesn't identify the caller. Switched the man, it was a man, to the fire department. They said, we'll be on our way in just a minute, which is basically the same thing as the dispatcher. It appears to me that everybody did try to get there as quickly as they could. But this is a concerned citizen, just like the other people were that called. But there's no facts in this complaint that his interests were so aligned with anybody in this accident, much less this young man.
What if the driver, Stacy, had made the phone call and the same remark was made, we'll send somebody on the way? Would that have created a duty? And I know she wasn't in a position to make it, but let's suppose that she had been.
If she had it, first of all, the complaint doesn't say that she couldn't have made the phone call.
Well, I mean,
maybe she was injured.
I assume that she was not in a position to call, but just assuming for argument's sake, would that change the equation?
Not necessarily. I think you would have more. Certainly you would have what they talk about, someone whose interests are aligned. Well, this is her little brother. Her interests are certainly aligned. So you would have that. But if all she said is, and I doubt that this would happen, but all she said was, I just crashed my car into the woods, that's not going to create a duty necessarily to this young boy. Now, I don't think she would have said that. I think she'd probably be screaming on the phone, I crashed my car, my brother's trapped inside, you got to come here.
Would that make a difference with regard to the duty?
I think if they had that information, that urgent information from the sister, she probably would have identified herself as the sister. She would have said something to alert them. The way the dispatcher got this information, they don't even know that somebody was involved in the car. But I think one of the reasons, I realize the language is difficult, but I think one of the reasons it is that somebody who is closely aligned, a sister, a mother, a brother, probably is going to make call after call, and it's going to be more urgent than a car has flown into the woods. It doesn't have to be, and I disagree with counsel, it does not have to be a relative, and I believe Judge Lewis stressed that in the hearings. It could have been a perfect stranger. Mr. Ng could have done a lot more than make a call about the car flying into the woods. The complaint indicates he made another call, but it doesn't say what he said or if he got a response or the call went through. But even if you assume at the time he made the first call, he doesn't know anyone's injured. He doesn't know anyone's trapped. If he's truly acting in the interests of this particular person so that their interests can't be separated, he's going to call back and he's going to say, look, this is worse than I thought.
What if he'd have just said, car flew into the woods, I know somebody in there is seriously injured, please get somebody here quickly. And they said, we'll do the same remark. Would you have a duty then?
No, I don't think so. Without more, I don't think so.
Why wouldn't you have a duty in that case?
Because what he is doing is reporting an accident. They think somebody's in the car. They're saying, yes, I'm going to be there. I think if he continued, and if they don't get there in reasonable time, and he continues, and he makes another call, I think that it can be. I mean, I have represented a sheriff in such a case where a citizen, a stranger to a victim, took extraordinary steps. And in that case, my evaluation was that it was sufficient. In this case, looking at this complaint, there's just not enough here to say that this man, however well-intentioned he was, meets this criteria that the Florida Supreme Court has raised. And I'm not going to argue all the other cases. I think they're fully briefed. But certainly in cases like Hartley and the case in Deerfield Beach, you had a great deal more. Hartley, there were specific promises made to that woman, and they weren't even accurate. And that is a classic example of when a duty arises. Also in the one where the wife's ex-husband had come to the house and there was problems with him and he had some sort of an injury. The paramedics had come there. They wanted to admit him. They said they wanted to admit him to the hospital. He says no. And they said, okay, if he gets worse, call us, we'll come back. That's way, way more than what we have here. We have various, that looks like 3, according to the complaint, well-intentioned citizens who tried to provide help. I mean, we've got law enforcement and fire department who did the best that they could. It's a tragic, tragic accident, but I think it would be very poor public policy for say governmental entities. Every time we have an accident in the state of Florida, you're automatically going to have some governmental entity liable. I mean,
Well, that's the general policy of the Pollock case. I think that the public policy that they tried to discuss here comes through loud and clear. But do you think they were just trying to draw a line? I mean, because I think there is some merit to the point that this could depend on who calls, and if you follow their distinction, and that doesn't seem quite fair. I mean,
I don't think it does. I'd agree.
Judge Lewis seemed to be troubled by it.
Well, it's difficult language to interpret. I'll admit that. It's difficult language, but I don't think it matters who calls in terms of whether they have a blood relationship with someone. I think it could be a Mr. Ng, but I think you're going to have to have a citizen, whoever's calling in, doing more than saying a car flew into the woods and making one phone call that we know got through. He made another phone call. We have no idea that it even got through. He's really no different than the other people who have also called in and got referred to the fire department. I mean, it's a tragic, tragic outcome. But under the facts of this case, and Pollock, I think, absolutely controls this case. I don't believe that Mr. Ng created a special relationship so that a duty of care could be imposed upon Sheriff Campbell. If you don't have any more questions, I will not take any more of your time.
Thank you.
Thank you.
Okay. First of all, as far as what we pleaded in this case, we pleaded there was a delay which caused the death of young Dorian Wayne. That is a question of fact for the jury to decide. Our issue here is really the question of law. It seems that maybe we're getting off on, what did the dispatcher say, or what did Leonard Inge say to the dispatcher? What Leonard Inge said to the dispatcher was never raised as an issue by the sheriff in the lower court. The issue was strictly his relationship with Dorian Wayne Penn Jr. Okay, so what was said really isn't an issue here on appeal. It was not argued below. Further, the case...
But I think they can argue the Tipsy-Coachman rule that if there's another theory that supports it, we can glean from the record, it could be affirmed on that alternate basis here, though. Can't we?
You can, but usually I think it's if there's harmful error, then you can pick up something that was not argued below. But usually if it's not harmful error, you wouldn't. In this situation, one of the things we need to get down to a person who's so closely associated that their interests can't be separated. I would submit to you that if you're standing there on the side of the road looking at a wreck and you're trying to get help for an injured person, trying to save their life, at that point, whether you knew them before or not, your interests are intertwined with that individual. You want them to get help. They want you to get help for them. Pollock does not forbid another person acting as an agent, obviously. But if Pollock wanted to limit itself, if the court wanted to limit Pollock to what the sheriff was saying and make this so narrow, it wouldn't have used the language or other person. It would have said friend, relative, somebody with a pre-existing relationship. It didn't. It wanted to make it broad.
Your time is up. Thank you. Please wait.